In a heated parliamentary exchange, South Africa's Minister of Justice and Constitutional Development, Mmamoloko Kubayi, has drawn sharp criticism for her comments on Afrikaner self-determination, particularly regarding the town of Orania, which some view as a symbol of cultural autonomy. The controversy centers on Section 235 of the Constitution, which recognizes the right of cultural, religious, or linguistic communities to self-determination, a provision rooted in the 1994 democratic transition to protect minority rights. The remarks came in response to a question from an Economic Freedom Fighters MP about criminalizing racially exclusive enclaves. Kubayi argued that white South Africans, including Afrikaners, do not qualify for self-determination under the commonly accepted definition, as it is intended for historically oppressed groups rather than former oppressors. She described Orania, a Northern Cape settlement where Afrikaners manage their own affairs, as using the guise of cultural self-determination to perpetuate notions of superiority and exclusivity. Section 235 does not grant any community the right to territorially self-exclude from the entire nation for the purpose of maintaining a racially segregated enclave, Kubayi stated, likening such practices to the Apartheid-era Group Areas Act of 1950. She emphasized the government's commitment to addressing all forms of racism, citing past prosecutions like those of Sparrow and Julius Malema. The Freedom Front Plus (FF+), a party advocating for minority rights, swiftly condemned Kubayi's statements as unbalanced and a direct undermining of Section 235 and the 1994 constitutional agreement that promised self-determination for all communities. In a statement, the party argued that self-determination is a safeguard against majority tyranny and applies universally, not just to victims of past oppression. They highlighted Orania's model as one that breaks from colonial patterns by ensuring all labor is performed by community members, rejecting accusations of racism. The FF+ has invited Kubayi to engage in dialogue to better understand Afrikaner self-determination, sending a formal letter to clarify their position. Section 235, often overlooked, allows for cultural groups to establish autonomous entities, potentially through non-territorial means like cultural councils with powers to promote language and customs, but requires parliamentary legislation to fully implement. Legal experts note that while it was included to foster reconciliation post-apartheid, its practical application remains debated, with Orania serving as a test case for territorial self-determination. The exchange has reignited broader discussions on national unity versus cultural preservation in a diverse South Africa. Critics of the minister's stance, including former F member Carl Niehaus, have echoed attacks on Orania, calling it a remnant of apartheid. Supporters, however, warn that dismissing such rights risks alienating minorities and eroding constitutional protections. As of October 30, 2025, the Department of Justice has not responded to the FF+ invitation, leaving the debate poised for further developments.